All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston for and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 6 cases we'll be hearing today. To my right and your left is Justice William Meade. To my left and your right is Justice Amy Blake. We are hearing all 6 cases live in person today. We will take a break after the 3rd case on our hearing list. The first 3 cases are criminal matters. The last 3 are civil matters. Each side has 15 minutes to argue. If there's more than one attorney arguing on either side of the V, please let us know ahead of time how you'll be dividing your time. I don't think we have any cases on today's list that fit that category, and there is no rebuttal. If you have more argument than you have time to reach, you may rest on your brief for whatever remains at the end of your 15 minutes. And of course, if you conclude your remarks before you run out of time, you needn't continue. We will have questions for you. The first case on our list for hearing is case number 2022 P318, the Commonwealth versus Januario F. Oliveira. Mr. Krowski.
I may proceed, Your Honors?
You may.
Good morning, Mr. Chief Justice, Justices. Attorney Joseph Krowski, Sr. for Mr. Oliveira. As a point of information, I was and according to the pleadings that I've presented, I was the trial counsel for the first trial. And the theory was that the firearm in question originated not from Mr. Oliveira, but from some source in the Boston Police Department, that it was also not a workable firearm because, as I said in my closing argument, it was a piece of junk. And also that there was some questions about the firearm, the vetting of the firearm through the Boston Police Forensics. The jury went out for 2 days and they reported back to Justice Roach that they were deadlocked 10-2.
Mr. Krowski, I omitted from my introductory commentary for the entire session my usual advice that we are familiar with the factual and procedural history. You needn't go over all of that, and you can jump right into the issues that you face.
I'm just trying
to appeal.
I'm sorry, Your Honor?
I said we are familiar with the factual and procedural history. You needn't go over all of that. You can just jump into the
Since I was familiar with the case, the Office of Public Counsel asked if I would do the appeal. Mr. Oliveira asked if I would do the appeal, so I got the transcript and I looked at it and I saw some areas that were very problematic. 3 days after the deadlocked jury, this court came down with a strike at the Commonwealth. The SJC came down with Commonwealth versus Wallace, which mandated certain inquiry by the judge in voir dire. Looking through the transcript, I saw that on juror number 7, that there was actually no voir dire. That was my first round of appeal, and I filed a motion for a new trial, and there were several other issues that came up. One of the issues was, and as I presented to this court, the failure of the defense counsel to hire a ballistics expert and failure to cross-examine on what turned out to be, I think, a very serious issue in the failure.
Can I stop you for a minute, counsel, on the juror issue? The transcript shows a pretty lengthy colloquy with juror number 7. So when you say there was no colloquy, what do you mean?
Well, after the fact, the Commonwealth relies in its reply brief relies on findings the judge made 3 years after. There was no contemporaneous voir dire of the juror. In fact, as I spell it out,
well, at transcript 1, page 21, that starts the colloquy.
And all it says is that we go down to juror number 7. Well, it just makes me have preconceived notions of consensus of like, I don't really understand why the police officers were called.
So is your view that there was an insufficient colloquy? Because you said no colloquy, and I have to disagree with you.
I still stand by that there was no colloquy, because under the Wallace case...
You must have a different transcript then.
All of the judge does was ask one or two questions, then he dismisses, and I think in a disdainful way, the juror by saying, all right, I'm going to excuse you from this case. There may be another case you would be wonderful on. I thought that was pretty disdainful and dismissive language of this juror who had waited all day to be seated, but in any event...
Mr. Krowski, over here.
I'm...
The juror number 7 said that she, after the statement of the case having been read, she referred to facts that she derived from that statement and said that she was inherently biased and that this case was unfair, and she didn't understand why the police arrested him, and she referred to the defendant as the victim. Why aren't each and every one of those solid grounds to find that she's not a proper juror to sit on this case?
Well, under the case found by this court several months after Wallace was Commonwealth versus Alves, in which this court relied on the United States versus Mason, and in the Alves case, the mere thought of somebody having a preconceived notion is not a disqualification. The judge did not go on to find out whether or not, with those preconceived notions, the judge's instructions would be forceful enough for the juror to put aside, though not put aside, but live with those preconceived notions and follow the instructions of the court.
I think that you keep saying Wallace. I think you mean Williams, right? Then Justice Budd's decision from the SJC, Williams. It's the one that's cited in your brief. Yeah.
And in that case...
I'm sorry. The difference here, and Judge Locke found as much, that the juror there had some worldviews that were not tethered to the evidence in the case. As opposed to here, the juror's views of inherent bias were tethered directly to this case and the facts.
Those findings were not made contemporaneous with the colloquy.
But he made them in the motion for new trial, which you've appealed in there before us.
3 years later, there was no record of the judge at the time when he should have made those findings.
It's the same judge.
Pardon?
It was the same judge.
Judge Locke.
What is our standard of review?
Standard review is substantial, I think substantial harm.
I think it's abuse of discretion, but
Abuse of discretion.
we extend a greater level of deference when the motion judge on a new trial motion was the judge who tried the case, right?
I think a jury selection is different, Your Honor, because you have to find out looking. As a matter of fact, in the Williams case, the court found that Judge Horahan had gone out of his way to make, for the record, make observations of the juror, that the juror was hesitant, that the juror was struggling, that the juror might have had problems dealing. So there was a colloquy at the time of the
impoundment, as there was an inquiry conducted here. Now the trial in this case preceded the guidance from the Supreme Judicial Court in Williams, but the judge conducted an inquiry to determine the source and extent of the juror's concerns, right?
But both times, in Williams and Alves, there was intervention by defense counsel. There was no intervention by defense counsel pointing out that there was an insufficiency in the inquiry by the judge, because the judge was just disqualifying the juror based upon...
Well, no, but the question, defense counsel, later intervened and pointed out alleged inadequacies in that voir dire inquiry.
That's
through
correct.
the vehicle of the new trial motion. The judge held a hearing and determined that there was no grounds for relief.
Well, we don't know what happened at the time, because, as I said, and I don't
We do know what happened at the time, because we have the transcript of the trial, and we have the judge's findings on the new trial motion.
I think we have to go by the record, Your Honor, and the record under Alves, under Mason and the other cases.
We agree that we have to go by the record, but the record is the record of this case, not the record in Williams, not the record...
I understand that the record in this case, Your Honor, is that at the time of the inquiry of the juror as to whether or not she could put aside, not put aside, whether or not she could listen to the judge's instruction. What the juror is saying is, I have to know more. She's asking the judge for some guidance on whether or not there's more to the case than that she's heard from that brief overview of what the case is going to be. So I suggest that there should have been more, that the judge is mandated by Chapter 234A, Section 67A, that's why we're here, discuss that statute where the judge must inquire when there is a question of whether or not a prospective juror can be indifferent. And I suggest that in this case, there is no way that the judge could have found, on the basis of the record at the time of the inquiry, at the time of trial, that the juror could have.
Counsel, let me ask you this. The juror said, I would be inherently biased to side and be more empathetic towards the victim, or in this case, the man sitting in front of us. What if instead she said, I would be inherently biased to side and be more empathetic towards the Commonwealth?
It's the same thing. The judge has.
That juror could be seated.
The judge has an obligation under the statute.
Answer my question. Could that juror be seated?
Pardon?
Could that juror be seated if she said she was inherently biased towards the Commonwealth?
That's the whole point. We don't know at this juncture whether she could have been not, because there's not enough inquiry by the judge. All the judge knows is.
What do the words inherently biased mean?
Pardon?
What do the words inherently biased mean?
That's innate. It's inside you. It's something almost congenital, Your Honor. Inherently biased. I don't believe on these facts anybody objectively could find an inherent bias. There is mandatory language in the statute requiring the judge, under these circumstances, with that minimal amount of information from the juror, to go further to find out whether or not they can be seated and listen to the instructions of the judge and follow the law. There are persons with preconceived notions that are seated, and Wallace says that all of these cases said once the judge has determined, the judge made no effort at the time of trial. 3 years later, at the motion for new trial, he did, but not at the time of trial. And I point out again.
Was this issue preserved?
That's the other issue. Wallace, defense intervention. Alves, defense intervention.
Wallace or Williams? I can't
Williams,
find the
I'm sorry, Your
Wallace
Honor. I was just, there was some information about an inanimate, the Wallace case just comes, it's Williams. Williams, Alves, Mason, and
Well, your
King.
brother argues that in your brief, it doesn't rise to the level of appellate argument for ineffective on this claim because you only have one brief statement about it.
One of the significant points in putting together a defense for a defendant is making sure you have a fair jury. You have a duty as a trial counsel to, as a matter of fact, if you look at the record appendix, there was a voir dire list of questions filed by defense counsel, and I think it's on my record appendix. It might be page 16, I'm not sure. But
Prosecutor, let me, we're running close to the end of your time here, and I just want to shift gears for a moment to give you an opportunity to address the Commonwealth's challenge to your 16L letter. You filed a 16L letter raising an entirely new issue. The Commonwealth says, I think correctly, that that's improper under our rule. But quite apart from the propriety of the content of the 16L letter, you suggest that the admission of guilt in his unsuccessful attempt to revise and revoke the sentence after conviction warrants a new trial. And I found myself a little puzzled how that works.
Well,
why does a post-conviction comment relating to the sentencing warrant a new trial on the question of guilt?
I think it goes to, at every portion of the trial, the advocacy is required to be zealous. I suggest that to file a frivolous motion under Rule 29. But what happened on the tape, I wrestled with this when I filed the original brief. And
I can
I had it
imagine
as an
that
issue, then
if you had thought about why a post-conviction error would call into question
Yes,
the
because-
underlying conviction, I think that would be
Because
cause
I
for
believe
wrestling.
if there's a meritorious issue that will send this back for a new trial, the defendant now is put in a position where there is an
Do you
affidavit.
have any case where a failure by counsel on a post-conviction proceeding affecting the sentencing was grounds for a new trial?
No, because I didn't brief it, but my
You
feeling was...
raised the issue, but this is one of the reasons why it's probably not a good idea to raise entirely new issues in a 16L letter. But, all right.
When Tate came down, I recognized it as an issue that I could have briefed, but what I'm doing is, as I said in my opening and my introduction to this case, was one of the issues that was raised as part of my strategy was the origin of the firearm was not from Mr. Oliveira, but was by some member of the Boston Police Department. What the defense counsel did in this case, under a misuse of Rule 29, was to just extinguish all arguments of reasonable doubt. So if this case went back...
Thank you, Mr. Krowski. I see that your time has come to an end.
I
Thank you
just
for your
wanted to
argument.
finish that sentence if I could. If this...
We'll hear from the Commonwealth now.
Okay.
Thank you.
Good morning. May it please the Court, Ian McLean on behalf of the Commonwealth. Your Honors, I'll start with the juror issues that seem to be the Court's focus here. The Commonwealth would say that the inquiry that Judge Locke engaged in here is analogous to the inquiry that the Williams Court pointed to in one of his footnotes. He pointed to a case Kennedy, and they suggested that would be an appropriate type of inquiry here, and that's basically what Judge Locke did here. That inquiry from Kennedy that they pointed to was asking the juror if any preconceived notion you had based on the facts of this case would impact your decision on whether to convict or not. So the inquiry was tethered to the facts of this case, and that's what Judge Locke did here in his inquiry. You can see on page 21 of the first volume of the transcript. He asked her
You
based
would
on...
consider that a colloquy, right?
Yes, Your Honor, absolutely. And his question was based on what little bit I've told you about the view of the case, meaning the statement of the case. Based on the facts you have thus far about the case, has that caused you to form judgments about it already? And she responded that it did cause her to form judgments about it already. She had preconceived notions. And as Judge Locke noted in his denial of the motion for a new trial, his decision to excuse her for cause was based not just on the content of her responses, but also based on him being the trial judge, being there in her presence, his observations of her. And I would just remind the Court that this is basically a credibility determination, and that's why appellate courts extend that extra deference to the trial court that's there with the juror and has the opportunity to see them face to face, as we never do on a cold transcript. So here Judge Locke asked an appropriate inquiry. He acknowledged that if he had had the benefit of Williams, he might have asked a couple of additional questions to ensure that he was satisfying Williams. But if you look at the footnote that Williams refers to in Kennedy, he asked basically that exact same question that the judge in Kennedy did. He just phrased it in his own way. So here there was no abuse of discretion in the decision to excuse this juror that had announced not only did she have a worldview, but she had preconceived notions about this case based on the facts of this case. So then briefly addressing the allegations of ineffective assistance of counsel here, it's regarding the firearm itself. It seems as though the claim could be claiming ineffectiveness in what defense the trial defense attorney chose to employ. That's clearly a strategic decision here. As you can see from the factual findings that Judge Locke made, this attorney was well informed. He had reviewed the discovery, visited the scene, met with his client, reviewed the transcript of the first trial, so he saw the gaps in evidence that happened in the first trial.
As best I can understand the argument, the claim seems to be that the failure to call a ballistician did not allow an adequate basis to develop a challenge to the chain of custody. And I'm not entirely sure I understand what particular expertise the ballistician would bring to that question, but that's
exactly correct, Your Honor, and that's as Judge Locke noted in his denial of the motion for a new trial. There's no need to call an expert to challenge chain of custody of a piece of evidence. And I'd also point out that this trial defense attorney did challenge the chain of custody. of that piece of evidence in two ways. The detective on the scene who recovered the firearm on the scene acknowledged he could not see a serial number on the weapon himself when he observed it at the scene. That's at volume 2, page 247. So the defense attorney did begin to challenge that process, and then he objected vigorously when the ballistician Chris Finn testified the following day about his ability to observe a serial number on the weapon. So he did engage in that challenge of the chain of custody. He just didn't employ an unnecessary expert who would have offered nothing other than to look at the records and say different people saw a serial number versus didn't see a serial number. So the trial defense attorney here recognized that that was not going to be the best defense to employ here, but because it didn't undermine his principal defense, he went ahead and pursued it anyway. He just didn't contact a needless expert to do so. So there's no ineffective assistance of counsel there on that basis. The other portion of the challenge would have been a potential challenge to the operability of the firearm itself. But in an ineffective assistance claim, there are two prongs, obviously. Did the conduct fall measurably below that which would be expected of an ordinary, otherwise fallible attorney? And was the defendant deprived of a substantial ground of defense as a result? Here, there's no evidence at all that the weapon was inoperable. It's never been tested by a defense expert, and there's never been an opinion that the weapon was inoperable, so there's no defense that he was deprived of here. And that's the easiest way to dispense with that claim. But I would also take it a step back, as Judge Locke did in his denial of the motion for new trial, and point out the trial defense attorney had no reason to believe the weapon was inoperable. At this point, it had been tested by two separate ballisticians and found to be operable. He did examine the weapon on the day of trial. If he had felt there had been some legitimate challenge to the operability of it, he could have sought a continuance and pursued an expert had he believed that was necessary. So I see no ineffective assistance of counsel there in his chosen defense. If the court has any questions about the Priority 1 broadcast or the perjury claim, I'd be happy to answer them.
Seeing none, I'll thank you both for your argument.
Wait. I have a question that relates to the fourth argument, that the judge should have reconsidered the motion to suppress based on the difference in testimony at trial. And I understand your argument and that there was little to no difference in the testimony where he was in the car or out of the car when he saw the gun. But my question is, has this court or the SJC ever permitted a motion to suppress a decision to be impeached with trial testimony that differs from what occurred at the motion to suppress?
So that would presume that it was remanded for a new motion hearing because he wouldn't ever have the trial testimony before that.
Have we ever said that a motion to suppress should have been allowed because the testimony differed at trial from the motion to suppress?
I'm not aware of a case where that's happened.
No, neither am I.
I'm aware of a case, the name is escaping me, it might have been Rodriguez, where they indicated a challenge on appeal to an incorrect ruling of a motion to suppress would be construed as a motion for new trial. But I don't think that it went anywhere in that case. They just acknowledged the possibility of it.
There, the issue wasn't based on a variation between the evidence at the motion to suppress hearing and the evidence at trial.
No, it was not. It was not. So to my knowledge, Justice Meade, no, it's not ever happened. If there are any further questions?
No.
Thank you.
Thank you both. Next case on our list for hearing is case number 2021 P1006, the Commonwealth versus JATAYVYN CRAYTON.
Good morning, Mr. Chief Justice, Your Honors. Daniel Katz for the defendant. As this court is aware, the Commonwealth has conceded on the second issue regarding whether the defendant could have been charged under that statute. And if this court has any questions, I am, of course, happy to answer them. If not, I will.
So the lesser included would be simple assault and battery without the aggravating element of assault and battery against a corrections officer.
Right, because.
So
he was convicted of assault and battery on a corrections officer and a separate count of assault and battery.
Yes, Your
What's
Honor.
the other, assault and battery was on whom?
Oh, I think that's, no, just the assault and battery on that officer.
So he got convicted twice for the same crime?
Well, the Commonwealth tried to charge him both with the felony and with the misdemeanor of simple assault and battery.
Chief already said that's a lesser included if it's on the same person or at the same time.
So he should not have been charged on.
All right, well, I'll ask the Commonwealth when we get to, go ahead.
What was the correction officer, Matthew Albano?
Yeah, he was not a correctional.
But that's, because if you look at the criminal complaint, count 1 is A and B on a correctional facility employee, no victim is listed. And count 2, it says assault and beat Matthew Albano.
Yes, Your Honor.
So if we accept the Commonwealth's concession, the A and B still stands, and you don't make a separate argument on the A and B?
No, I am making a separate argument because of the motion to suppress, if that had been.
Understood.
Yeah.
Okay.
So I'll move to that one, Your Honors.
Please.
Okay.
But as you do, please, you're familiar with the Commonwealth's argument. Obviously, you've read the Commonwealth's brief because you know about their concession on the ABCO. You are therefore also surely aware of the very lengthy description of our case law that holds that simply being resident in a DYS facility does not put a person in custody for purposes of custodial interrogation.
That is true, Your Honor. But there was that additional element.
So why don't you identify the particular factors in the conversation that took place here that suggests that this is not, as the Commonwealth contends, a non-coercive setting within a custodial facility?
Gladly, Your Honor. So if you look at the transcript on page 67 of volume 2, the defendant is in his cabin, and the program director goes into the cabin, and the testimony that we have is that trooper says Mr. Waite went into and asked the defendant to come out. I would ask Your Honors to look at that and imagine that being in his shoes, that it's more of a direction, a directive. Young man, you are not an adult. Come out and speak with the troop, or come out of the cabin. So I think,
If it was a dorm room at a college, and the resident advisor on that floor made the same request, would that be custodial?
I think so, Your Honor, because what you have there is you have, if you look at the status of the two people, you have, you have the juvenile, right? And then who's 17 and maybe a half. And then you have the program director, like the resident counselor in college, who may be another student, but still.
So I understand that's your position. You've answered my question in the affirmative. And now I'm going to ask you, it won't surprise you to hear me ask you for the case that comes closest to supporting that proposition.
I do not have a specific case, but what I did do.
It often seems to be the case these days.
Unfortunately, Your Honor, I wish I could say the XYZ case.
It's always better for your argument if you have some support.
Yes,
right?
boom, victory for defendant. But if you go through the factors that the SJC is telling us we have to go, not exclusive, and yes, we are required under Larkin and Smith, Your Honors are required under Larkin and Smith to have this extra element, I would implore your honors to look at the fact that in the status relationship between the juvenile and Mr. Waite, identified as a program director.
Other than the fact that we have a hierarchical setting here, where you have someone with some measure of oversight of the juvenile's activities, are there any, and I get it, are there any other factors that you suggest weigh heavily on the coercive or custodial character of this interaction?
Yes, Your Honor. So Mr. Waite says, I would like you to imagine.
Like you to come out.
Yes, direct, come out.
That's okay.
Imagine you're in his shoes. Do you really have a choice? I truly honestly don't think so. You go out and
But it's
only
not-
10 feet away.
Just to stop you right there, it's not just does he have a choice on whether to, as a practical matter, to engage in a conversation. That doesn't, the officers on the street, we know quite well, can walk up to any individual and initiate conversation without immediately transforming that into a custodial interrogation.
Right, but first we start off, okay, he's in a facility, not sufficient, right? Director, Mr. Waite, come out. Okay, seriously, in his shoes, you have to come out.
But it's not a question of whether he had to come out. It's a question of whether he could stop the interrogation.
Okay, so
as was found by the motion judge, in a very non-aggressive, calm tone, the trooper merely asks him what happened. That's the entire interrogation. And he tells him, and then he goes to bed.
But just because there is a non-aggressive tone does not all of a sudden let the Commonwealth off, boom, no custodial interrogation.
No, there's four factors. But that is one of the factors.
Right, but
So that weighs in favor of the Commonwealth, right? Okay, so, I think you've conceded that the fact that he's in a custodial facility doesn't mean he's undergone custodial interrogation in and of itself.
correct, but
He's also not arrested at the end of the discussion, right? That's also a factor.
yes, Your Honor, but he is directed to come out, and what does he see? He sees a trooper in uniform, only about 10 feet away. The trooper has a gun. His hand is not on the gun, but imagine in his shoes, as you know, are required to do, taken in consideration the age, a juvenile is directed to exit his...
Is he a juvenile? He's
17 and a half. So it's not a situation where we have, as I was discussing with Chief Justice Green, it's not a situation where there is an equal status. And the United States Supreme Court, I believe, I didn't cite it in my case, but age must be taken into consideration. Even though the trooper's hand is not on the gun, the trooper is in uniform, has a gun, There are no other suspects. And so what I'm trying to implore Your Honor is that
there's a fight between two people.
Right. Sometimes in the cases which I've cited, the courts make a distinction between whether, even if the questions are not pointed, if they are focusing only on what this person did, as opposed to what did you observe, right? That's not the question, even though it was said in a conversational tone what happened. It is a pointed, laser-focused, open-ended question, but still pointedly directed at this juvenile who has just been...
I'm having trouble conceiving how asking someone what happened is a laser-focused question.
Because it's not...
It said, why did you hit him repeatedly? Then I'd say that was focused.
But imagine, Your Honor, it's not like there was a melee in the cabin and there were other people and this, my client, the defendant, was one of several who were being investigated. Rather, this question had an accusatory to get his side of.
Well, yeah, those two statements, an accusatory and to get his side, stand in some tension. Because if there was any exculpatory information that the juvenile had to bring to bear on the evaluation of what happened, that was his opportunity to do so.
But if the officer had, if the trooper had said, what did you observe, trying to create the scene, but I would implore your honors to look at it as a pointed question that is accusatory of what did you do, although those words were
No,
not.
it's inculpatory to the extent that the juvenile had no exculpatory information to share. But it's not accusatory in the sense that it was so open-ended that if there were exculpatory information, it was entirely open to the juvenile to offer it.
But it was an accusatory statement because it's not the incident in question. He was the only other party beside the alleged victim. So if a trooper is asking you what happened and the context of what happened is not a
Well,
group.
let me just focus my skepticism a little bit more sharply. Had this been a circumstance where there was a valid defense of self-defense, the fact that there were no other people other than the two protagonists involved would not make this particularly accusatory. This was an open-ended opportunity. If there were any exculpatory elements that the juvenile could bring to bear on an evaluation of that conflict, it was an opportunity. So we've covered two of your bases that suggest, you say, that this should be viewed as custodial and coercive. Are there any other elements that, because you're running short on time, are there any other elements that we should weigh heavily on this equation?
Let me just run through. So we have the fact that it's a juvenile, the fact that, yes, it's not sufficient that he's in a DYS facility, but that he's directed by a superior to go out to meet a trooper who has a weapon, who's in uniform, in which there are no other potential people involved. And despite the conversational tone of the question, it was pointed and accusatory. And thank you, Your Honor.
You asked us to transmit the video, but the video is of the A and B, right? This exchange with the trooper is not on the video.
Right, I just thought I should have done it sooner, just for a matter of completeness, if Your Honors, because if you go along with my argument and then get to prejudice, I thought perhaps you would want the full picture, even though.
Why isn't the video, or why aren't his statements entirely cumulative of what appears on the video?
I'm glad Your Honor asked that question, and in 10 seconds I will say, because on transcript, there's the correct site, volume 2, page 67, the prosecutor, neither the prosecutor nor the judge rely exclusively on the video. They talk about all the evidence. So therefore, given the high standard that the Commonwealth has to meet, I still think it would be an error if the judge had just said, I'm exclusively relying on the video.
Thank you.
Okay.
Thank you.
Thank you, Your Honors.
For the Commonwealth?
Good morning, Your Honors. Karen Palumbo for the Commonwealth. May it please the Court. First, I'd like to point out that it is the defendant's burden to prove that the juvenile was in custody. I would suggest that
Can I ask you about your concession first?
Yes.
seems like this has been under the radar. Are you aware of any other cases? Is this something that's been brought to the attention of the legislature, if you know?
I don't believe so, no.
Are there any DYS facilities that would fall under the category of this statute?
No, I consulted with the acting commissioner of DYS, and they are a separate entity.
Okay, thank you.
You're welcome.
The victim is the same victim in both counts.
Yes, he is.
Has it occurred to anyone before myself this morning that he can't be convicted of both of these crimes?
It did not, and it was not raised by the defense. But I think, given that we have conceded the AB corrections officer, that this conviction can stand.
So that he doesn't need to be resentenced?
No, because he received a concurrent
Vacate
sentence.
the greater offense?
No, he received the same sentence, 1 year to the House of Correction, concurrent with the second charge.
But we still need to vacate his conviction
Okay.
of the greater offense, given your concession.
Okay, then maybe that's true. But,
One victim, we can only have one conviction of AB on arising out of a single incident.
yes,
Okay.
even though it was there was an additional element to the statute, I still believe it was one victim and it was one assault. So it's one conviction. But again, it's the defendant's burden to prove custody, and I would suggest that he has failed to do so in the circumstances of this case. Again, the court's very well aware of the facts, and the defendant, the question of whether he's a juvenile or not, he was actually not a juvenile at the time of the assault, however, because he was charged in district court. But however, the trooper believed he was a juvenile. He believed he was 17 years old. So simply asking an individual what happened is not interrogation. It's one question, and the defendant did answer, but as the court has said, he could have provided exculpatory information as well. I would suggest this case is more akin to Commonwealth v. Larkin, where the defendant was in prison, in custody, and there were no additional restraints placed upon him. In this case, there were no additional restraints placed upon this defendant. The case, maybe I won't say that, but in any event, even if the court were to find that there was custody and there was interrogation, which the Commonwealth does not concede, in the circumstances of this case, where there's a video of the entire incident, I would believe that any error would be harmless beyond a reasonable doubt. If the court has any other questions? All right.
Thank you
I'll rest
both.
on my brief. Thank you.
The next case on our list for hearing is case number 2022 P590, Commonwealth versus Arguelio G. CAJIGAS. Just a reminder, we will be taking a brief recess following the conclusion of the argument in this case before we resume with the civil portion of the list.
Good morning.
Good morning.
May it please the Court, James McKenna for Mr. Kajigas. The Supreme Judicial Court could not have been more clear. The Commonwealth had a duty to investigate thoroughly and in a timely manner the conduct of Sonia Farrak, the chemist.
Can I stop you for a minute?
Yes, please.
I know you say in your reply brief that you're not asking us to overrule CPCS because you know we can't, but that you're asking us to expand it.
Yes, Your Honor.
So I guess my first question is, can we do that? And my second question is, did you seek direct appellate review and raise these issues in a request for direct appellate review?
Yes to both, Your Honor. Yes.
And what happened to your request for DAR? I assume it was denied.
It was, Your Honor.
So can I infer from that that if the SJC thought they got it wrong or they made a decision on, I think to use your words, an infirm record, they would have grabbed it and said, we better fix what we got wrong?
I would hesitate to say yes to that, Your Honor. I don't know why it was not allowed. I just don't know.
Well, let me put it a slightly different way. If we decline your request
Yes, Your Honor.
to expand the holding of the SJC and CPCS, it would remain open to you to raise the question with them again that they take this case despite their unwillingness to take it before.
Absolutely, yes, Your Honor.
I saw when I did some investigation that you had sought direct review and that it was denied, but I wasn't able to look at the petition for direct review, but you can confirm that you raised these claims in that application.
Absolutely, yes, Your Honor. The same exact material.
All right.
And you agree that Pontes tested all of the drugs in this case?
Yes, Your Honor.
Just as a housekeeping matter, we have the drug certs for the Class A, but not the Class B in the record. Is there a reason for that?
I don't know. I would presume that we could supplement the record with the Class B as well.
I just didn't know if there was something unique or special about them.
No, Your Honor.
So Pontes tested them in 2006, right? May of 2006 at the Amherst lab,
Yes, Your Honor.
right? And Farrak was at Amherst from '04 to 2013.
Yes, Your Honor.
Is there anything in the record, she was not the confirmatory, right? There's nothing on paper that says Farrak touched this case. You're suggesting that there just wasn't enough put before the court. And so basically, anybody that had a drug conviction, no matter who tested it or who was the confirmatory, should get their convictions vacated, right?
Yes, Your Honor. Please, Your
But was
Honor.
Farrak's issue methamphetamines?
Not just methamphetamine, Your Honor. It was basically whatever she could find, from LSD to cocaine to methamphetamine to other
What
amphetamines.
about heroin?
She used heroin as well, Your Honor.
But, I mean, this remedy that you're asking for now was specifically requested in CPCS,
Yes, Your Honor.
specifically considered, specifically addressed and rejected by the Supreme Judicial Court in their decision in that case.
And we would have nothing to support our argument. We would have nothing to support our argument had it not been for the Sutton decision. In Sutton, what they did...
I'm sorry, before you get to Sutton, I have a variation on the Chief's question. You want us to vacate all of the convictions during Farrak's tenure at the Amherst lab?
Just the ones from her arrival until January 2009.
Okay, so more than your clients?
Yes, Your Honor.
Okay,
Well,
so how do you have standing, and from where does our authority find its genesis to do something like that?
Your Honor, if I could take back my answer just from a moment ago, I just want my client's convictions vacated on the basis that all those convictions should be gone. To Justice Blake's point from a moment ago, yes, this was Pontes. There was no indication that Farrak touched these drugs at all. And if this had been done in 2010, not 2006, Mr. KAJIGAS' convictions would be going away.
So you're withdrawing argument 3 in your brief?
No, Your Honor. No.
Well, you asked for all the convictions based on the integrity of the Commonwealth's evidence be vacated, and I'm stuck on standing and authority. We do not have general superintendent's authority over to the courts. Only the SJC does.
I would restrict then that part of the argument to just Mr. KAJIGAS' case, with a ruling that would apply equally well to all those other cases. But,
Which you don't have standing to bring.
yes, so I would suggest that, for that reason, we would only ask that Mr. KAJIGAS' convictions be vacated, or a new trial be allowed.
Okay, I'm sorry. And you were
So-
going to talk about Sutton. Go right ahead.
Thank you, Your Honor. In Sutton, the Middlesex Superior Court established by finding a fact that there was no investigation of what Farrak did at the Hinton lab. The SJC said, we've got to do a thorough investigation. They didn't do a thorough investigation of what she did in
That
that.
was Judge Raschudi's case, right?
Yes, Your Honor.
Did that go up?
No, Your Honor.
So we're
And
not bound by it.
I'm sorry, Farrak was the chemist in Sutton, too.
Yes, Your Honor. And the usefulness of Sutton here is that it establishes that nobody investigated what Farrak did in the Hinton lab. Nobody has. It's 10 years next month, and nobody, no part of the government, no part of the Commonwealth has to this day investigated what she did at the Hinton lab.
Well, let me ask you, CPCS at 729 says that the class of Farrak defendants entitled to relief includes not only cases already dismissed where she signed the drug certs, but all convictions based on evidence that was tested at Amherst on or after January 29, irregardless of who the chemist was. And we agree that these drugs were 3 years before that, right?
Yes, Your Honor.
Was the argument made, it seems to me it was, but I'll ask it anyway, that all the drugs should have been, every test since, I guess going back to 2002, when she was at Hinton, Did CPCS request that all of those convictions be vacated?
My understanding was they requested all from 2004, her arrival in Amherst onward
Okay.
be vacated.
So I guess I go back to where I started, which is, I know you're wordsmithing, and I appreciate why you're doing that, but expanding is the same as overruling on these facts. We're saying, hey, SJC, you got it wrong. You have to back it up.
Their ruling in CPCS was based on the understanding that there had been an investigation directed towards Farrak at the Hinton lab. That's where the sole bad actor part of the Inspector General's.
But it seems to me this argument is like, if she was in the building, she must have done something, so we need to vacate them.
We don't know if anything she did wrong at Hinton.
But, so again, I mean, she's not in the building. Help me out. Maybe I'm slow. So these drugs were tested by someone other than Farrak in Amherst, not in Hinton. So the failure to investigate what she may or may not have done in Hinton relates to this case how?
Because the understanding of the SJC in CPCS was that she began her misconduct at some point after her arrival at Amherst. And that's because they had this, I'll use the word nonsense, from the Inspector General's office about about the fact that Duke had been the sole bad actor at Amherst.
But to make something out of this at this level, don't you have an obligation to have some proof that something was done improperly in Hinton to say they should have found this? Look what she did in Hinton.
Except, Your Honor, that without an investigation, I couldn't have that proof. And nobody has investigated what Farrak did at Hinton. Nobody. And without that, ARGUELIO CAJIGAS couldn't know.
But there still has to be some sort of logical connection between what she did or didn't do at Hinton and what was tested by a different person in Amherst.
If it had been done, this is the key to our argument in a way, if it had been done in 2010, it would be dismissed based upon CPCS. The only thing in CPCS that we're seeking to have expanded, and perhaps not reversed, would be the timing of the vacature date. They put January 1, 2009, and that's based on what?
I understand the theory and the basis on which you're trying to proceed. And I also am sympathetic to the posture in which you find yourself in this courtroom.
Thank you, Your Honor.
The second floor issued the decision, CPCS, they considered this. They considered your application for direct review, and they may feel differently on an application for further review, but I view what you're asking us to do as being, frankly, beyond our proper role as an intermediate appellate court.
And we still have their address in the event that the court...
You know where to find them. I mean, you can actually, you won't have anything on your way out of the building today, but I suggest that there certainly will be no offense taken if you ask them to take another look at this after you get what I anticipate will be an unfavorable decision.
On that note, Your Honor, unless there are any further questions, I'll rest on the brief.
Thank you.
Thank you, Your Honor.
From the Commonwealth?
Good morning, Your Honor. May it please the Court, 88.
More that you'd like to tell us?
I just wanted to very briefly make one point, and that's obviously there's been this discussion of Farrar Scott. I won't get into that. That's in my brief. There's also a discussion that this Court has already had with Mr. McKenna about CPCS. One of the things that Mr. McKenna talks about is that, well, in Sutton it doesn't say, oh, but CPCS. But the answer there, as Justice Meade pointed out earlier, is that Sutton is a Farrak case. In his reply brief, Mr. McKenna says that it is against common sense that the Commonwealth would have a duty to investigate Farrak as to Mr. Sutton and those similarly situated, but not as to Mr. CAJIGAS and those like him who had their substances not tested by Farrak. But that's actually a perfectly reasonable reading of the law, which is that constitutional rights are, as a general rule, individual rights and cannot be argued on behalf of another. That includes, as to the Fifth Amendment, there's a matter of a grand jury investigation, one of those cases. It's 418 Mass 549 at page 552, that's a 1994 case, that notes that the Fifth Amendment right is a personal right, cannot be asserted on behalf of another. So I'll simply note that Mr. CAJIGAS cannot assert Mr. Sutton's right to have the Commonwealth investigate, which is part of the
Can I
Commonwealth.
ask you a different question, because you're from the county, right, where the lab is, and you gave us the 128 of Otero. Are there a lot of cases in Hampden County that are raising these issues?
Less than there
In
used
other
to
words,
be.
do we need to publish this, or do you think that these are just a couple of one-offs here and there?
The number used to be higher. Publications stating that a case in which Ponce or Hanchett tested the drugs, that the fact that it was simply at the Amherst lab is not good enough, notwithstanding what's happening at the Hinton lab. Publication of a case saying that might be helpful.
So Otero is the only case you found? There's nothing published that you know of?
I've actually...
I couldn't find one,
I've
but-
personally handled all of the...
You do?
Cases out of the Hampden
You
County.
handle them,
I
so you
personally
would know.
I believe this is the only one that has made the specific argument that the Otero and this one are the only ones that have made the specific argument
I mean,
that
back to
failure to investigate.
Got to be a closing window, right?
It very much so, Your Honor. 4 years ago, I was in a mad scramble.
Farrak's been gone for 10 years, right?
Yes, Your Honor. 4 years ago, I was in a mad scramble to find all of the cases, deal with all of them, and I spent the year thereafter doing nothing else.
You have a counterpart in the Suffolk DA's office who had yeoman's duty.
Yes, Your Honor.
As a coping mechanism, I try not to spend too much of my time thinking back over these last years.
Likewise, Your Honor.
All right, anything further?
Nothing, unless this court has any questions about the points raised in either my brief or the defendant's reply brief.
Thank you.
Thank you.
The case is concluded. We are in recess. We will resume at 11:15.
Court all rise, please. Court is now in recess.
Thanks, Mark. Thanks, Mark.
This court is now in session. Please be seated.
Good morning. We resume with the civil portion of our hearing list with case number 2021 P-1074, John Doe, number 39523 versus the Sex Offender Registry Board. Mr. Gauthier.
Good morning, Mr. Chief Justice and members of the panel. May it please the court, for the record, my name is Edward Gauthier, and I'm arguing today on behalf of the plaintiff appellant John Doe. Mr. Doe was finally classified as a level 3 sex offender, and we have appealed. Your Honor, before I go to the meat of our arguments, I'd like to bring up something that's not in the record and is not briefed, but has been discussed by my brother and I the past 2 weeks, and that's the fact that this case is arguably moot. My client was finally classified 3.5 years ago, and as a result, he is entitled at present to the relief that we seek in this appeal. We're asking for a new hearing. The board has offered my client a new hearing. Unfortunately, my client can't have a new hearing at present because this appeal is pending, and individuals before the board cannot have a new hearing while their issues are pending either in the Superior Court or in this court, which means that regardless of how this case is decided, the relief that we're asking for has been offered.
Do I understand you to be raising an oral motion to dismiss the appeal as moot?
No, Your Honor. I'm simply pointing out in advance that I'm prepared to discuss an issue that I anticipate my brother is going to speak about.
Do you have any reason why we ought not to dismiss this appeal as moot?
Well, Your Honor, my client has the right to pursue an appeal, even if the appeal is arguably moot, and I do not have, I don't have...
I just want to get beyond the description of arguably. Is there any respect that you can identify for us that would suggest that it is not moot?
I cannot, Your Honor. However, as an officer of the court, I can tell you that I am not authorized under any circumstance.
I understand that.
Is this the only thing that's pending? Is there anything pending in Superior Court?
My client has no open cases, Your Honor. This is it.
I understand that you cannot drop the appeal in these circumstances, although I do also understand that in these unique circumstances, it may well be in your client's best interest if the case were dismissed as moot.
Actually, Your Honor, I concur entirely that if this case is reached, the court has one of two choices. It can declare that it's moot, or it can reach the issue that we've raised. If it reaches the issue that we raised in a way unfavorably to us, that provides law of the case, which could be damaging during the hearing.
Well, and beyond that, any delay in the issuance of that decision,
of course, Your Honor,
would delay his opportunity to proceed with the new hearing that has already been authorized.
I concur 100%.
You're not moving to dismiss. Are you objecting to a dismissal?
Your Honor,
There's a difference.
He's duty-bound to do so, but he's offered no basis on which that's available to him.
Thank you, Mr. Chief Justice. I am bound to pursue my client's interests as he states them to me. I cannot move to dismiss or assent to a dismissal. I can simply tell this court that it is arguable that because my client is entitled to the relief that we've asked for in our brief, that the case is effective.
Can I ask a different question that relates to dismissal?
Yes, Your Honor.
So judgment in this case entered in January of 21, right?
Yes, Your Honor.
And then the councils found out at some point later on, and then waited an additional 2 months to file an emergency motion to file the late notice of appeal, right? Have I got it right so far?
Yes, Your Honor.
And the trial judge allowed that late notice of appeal.
Yes, Your Honor.
But Rule 4C only gives the trial court judge an extra 30 days, not 6 months.
I understand that, Your Honor.
And no one came to the single justice to ask for time under Rule 14.
That would be the case, Your Honor.
So we don't have jurisdiction in this case because the notice of appeal wasn't timely.
I don't know the facts and circumstances, Your Honor. I was not assigned to this case until a little after.
No, I just want to. I'm not blaming you. I'm saying, just looking at the docket, there's a problem here.
Well, that would be one way.
Have I got the timing wrong?
I believe you have the timing. I'm not going to quibble with the timing argument.
Okay.
I believe that ultimately this court is going to dismiss this appeal, whether on the grounds of imperfection of the appeal or mootness. I'm just here to stand for my client and pursue the interests that he has asked me to do.
As to the merits, beyond what you've said in your brief, is there anything else you'd like to say to us?
Just one thing, Your Honor. We do not quibble with the findings of fact. They're supported by the record. We don't quibble with the application of the various high-risk, risk-elevating, and risk-mitigating factors. Each factor can stand within the record evidence. What we quibble with is there's no discussion based on the findings of fact exactly why community notification is necessary. My client offended against an adult man while he was serving a sentence. The community notification provisions don't exist to protect people at the prison. They exist to protect people in the community. His community victim was a 15-year-old girl when he was 20 years old, and they had, but for her age, consensual sexual activity that was neither forced nor coerced, and there was no violence. That occurred more than half of my client's lifetime ago. So we essentially have one offense in the community where my client sexually offended against a 15-year-old girl. A 17-year-old boy was also present, and there's no evidence or any suggestion that it was a violent offense. In fact, my client got probation for that. Our argument is that the decision simply doesn't spell out why the factors ineluctably lead to a level 3 classification. They find the facts. They find the factors. We have no quibble with that. But how do you go from there to a high risk of reoffense? And the purpose of the community notification is for who and why. And our position is that they just don't spell that out in the decision. If there are no further questions, we would rest.
Thank you, Mr. Gauthier.
Thank you, Your Honor.
Mr. Chennai?
Thank you, Your Honor. Chief Justice David Chennai for the board. I want to be clear. This individual wasn't offered a new classification hearing. What I said is if you dismiss it, we'll start scheduling for a reclassification, which he was eligible for. Dismissal of this case would still require the board to have judgment in the case as a level 3 sex offender. And then he could go for the reclassification. That's the board's position in this matter.
Dismissal of this appeal would make that judgment final.
Correct. And that's correct. And Justice Meade, I must say, I didn't even see that issue as to the actual timing of the original appeal. So there may be a jurisdictional issue.
An order of the trial court judge authorizing a late notice of appeal, but that was not proper under Rule 4. If the authority exists under Rule 14, I don't know whether we want to deal with it as a matter of jurisdiction on the notice or jurisdiction on mootness, but
well, sometimes you get so tunnel visioned on the actual offenses and the factors, sometimes these small things slip through the cracks, and I'm sorry I didn't catch that. And I think as to the issue of community notification, I think the hearing, again, this was prior to 496501, so the hearing examiner back then would not have made that individual specification as to internet dissemination. But I think the facts are pretty clear in this matter that internet dissemination is warranted under this individual circumstances. And the thing that I would point out is that while he was in the community, he continued, even after his sex offense conviction, to have really inappropriate contact with children, providing them with alcohol, providing them with ecstasy, and making sexual innuendos, and in one case, actually physically touching a girl in a sexualized manner, a 15-year-old girl. So I think that all harkens to the board's decision that dissemination was appropriate in this matter. And I think that the court under 496501 could make that determination itself today. Based on that, the board would rest unless there's a specific question in this matter.
Seeing none, thank you both.
Thank you, Your Honors.
Our next case is case number 2021 P968, John Doe, number 187531 versus the Sex Offender Registry Board.
Good morning, Your Honors. May it please the Court. Alexi Tomasco for Mr. Doe.
Mr. Tomasco, before you begin, I want to extend our appreciation for the circumstances in which you find yourself here today. We are well aware that you came into this case quite late in the game and under circumstances that had you had an opportunity to intervene earlier would not have arisen. And so as you proceed through your argument, have no fear that we will not take into account the difficulties that you face by virtue of the circumstances that bring you here today.
Thank you, Your Honor. That was going to be...
Probably ruined your weekend, right?
Oh, I won't even get into the details, but I was going to ask for indulgence for both being rusty and being poorly.
You know, in other circumstances, a year ago, we took a different posture on these sorts of things, but we are at a point where our posture and the bases for good cause have been well understood and publicized for some time. We issued that formal policy for a reason, and we felt that it was important to make that clear.
Thank you, Your Honor. And I won't belabor the point. I did want to just briefly address the circumstances of my being here. And I've been before this court for quite a long time. Rules are rules, and I understand that there's an expectation that part of practicing before the court is being in person. I think 3 short points I would like to make are first that rules are rules, but they don't abrogate the Constitution. And this court and the Supreme Judicial Court have both taken opportunities to address, certainly within the trial courts, the conflict between maintaining a regular order and also preserving the Sixth Amendment and due process rights of indigent clients in particular. I haven't had a chance to speak to a client in this case, and I was presented with the choice of either appearing in person without having spoken with the client or waiving argument, and that's a difficult choice, but I went with the more palatable of the two. I would also just, and again, I'll go through this just as quickly as possible. As part of my position, I have to get bar advocates to take these cases at 1/6 the billing rate for private cases. And there may be a very small line of individuals for defense cases. There's a minimal line of individuals who are interested in taking sex offender cases or SDP cases. And as it is, we're seeing a shortage of bar advocates in Boston Municipal Court, which is shocking to me, all of Western Mass, both for CAFL and defense cases. And so, again, I understand this court's rule. I don't think I've ever appeared remotely, but what today is a scheduling issue could become a Sixth Amendment issue down the road if I can't find bar advocates. And I would say, for the record,
we will take that into account as we continue our dialogue, but we would not impose, and we did not put you in the position of needing to waive your client's rights. We were taking that decision away from you, as is our authority in cases that we determine can be disposed of appropriately without argument. Had the case involved issues that we thought required oral argument in order to understand them and address them appropriately, or in order to discharge due process rights, we would not have done so. In this case, we thought we could. Having used 4 minutes of your time, I'm still confident that we can address everything we need to in the time that remains.
I had 1 more minute before we got to the substance, and first I just wanted to put on the record that Attorney Green is fabulous. She is really a credit to our bar and our
appeared in front of me several times before.
The right to counsel is a statutory right in these cases, right? It's not. It doesn't derive constitutionally based.
Yeah, I was curious about that question. There's also a question, I think, in my mind, and I've certainly had for a long time, about what exactly is the constitutional right to an appeal at all for anyone. I think the SJC has spelled that out to some degree for criminal cases, but I think you sort of get in the penumbra of due process rights, which is to say, is it inherent in a due process right for an appellate court to be able to view or guarantee that the due process rights were followed? I think that's right, that there is some question as to...
Well, I mean, even without your appearance today, Mr. Doe has not been deprived of counsel.
That's correct, Your Honor. But I think we're quibbling about exactly the nature of the Sixth Amendment.
I don't know what we're quibbling about. I thought we were indulging you, and now you're criticizing us.
Oh, no. Well, so, I mean, I guess the only other thing, and again, is just that I think the irony here is that we have been fighting for quite some time to get in-person hearings for our clients, which we've lost. And so the irony here, I think, is that we have sort of a Schrodinger's hearing where simultaneously a client must and may not have a live hearing. That said, rules are rules, and I want to turn then to the first argument, and here are the, again, it's a repeat of the element analysis and another issue there. I'm not going beyond the brief in terms of an argument as to the actual weighing or the criticism of the discretion of the hearing examiner about how to weigh the various factors and whether those that are in favor of the client versus those that cut against the client, that weight was necessarily incorrect. But rather, I think I'm looking at error that, looking at both the Superior Court filing and speaking with counsel here, as to the danger and reoffense designation for Factor 18 and Factor 19, the hearing examiner applied these factors to the risk of reoffense. And that's just error. And I don't think there's any dispute as to whether that's error. The question is going to be our question of harmless error. The second question is the issue of the following the entire commandments of Factor 10 in terms of a prior criminal history. That factor, of course, calls for the consideration of the disposition of the charges, and that just didn't happen. Shall, of course, is a mandatory or imperative obligation. There's no discretion here. I'd note in 524553, that's actually an example where, and again, Justice Blake, I believe you were on that panel, there was an inquiry about the difference between dismissals and quaffs and probation, so there was a functional analysis there, and that just wasn't here. There's just simply...
Is there a case in which Factor 10 was applied without mention of the dispositions and we found error?
I'm sorry, Your Honor, I don't know off the top of my head. I could not find any.
That's your issue here, though, on Factor 10.
I think it's more fundamental than that. It's just that the factor requires that, and it didn't happen here. Again, I think the inquiry turns then to harm, but the factor is just plain here, and I think it's also plain on.
He had a substantial criminal history.
The question and the rules standard here is that the regulation calls not just for an examination of the criminal history, which goes beyond the hearing examiner can consider charges that are dismissed, can consider charges where the victim recants that the police report is still subject to review by the hearing examiner. Under Factor 10, one of the commandments is that there has to be a consideration, there shall be a consideration of the dispositions, and that didn't happen here.
But if we agreed with you and said that the hearing examiner erred as to Factor 10, does the whole house of cards fall, or is there still substantial evidence?
Well, I would note two things. First of all, I think the Factors 18 and 19 violation is more severe than 10. So I think if you're saying Factor 18 and 19 are fine, is 10 alone going to be enough? I'm not sure, because certainly there is a criminal
I think the question really is if we take everything that is unassailably available.
Yes, Your Honor.
Is there substantial evidence still to support the disposition, the classification?
So putting aside the checklist analysis, which I think is also something that comes into play here, the analogy I use here is that this court has always been reticent to step into a hearing examiner's shoes in terms of assessing the body of evidence. There's a body of evidence. The hearing examiner is an expert and makes a diagnosis or a prognosis of the health of the client, says a 1 or a 2 or a 3. And what we do here in terms of analyzing legal error is we take that body of evidence and we excise the cancerous error. And then the question is, what do we do with that next body of evidence? What I suggest is that I think that same reticence to analyze that original state, that original diagnosis, should really be very similarly applied to what happens afterwards.
We've been doing that with a fairly explicit endorsement from the SJC in the Factor 2 setting.
That's correct, Your Honor. And in terms of the SJC has also given guidance in terms of failure to extensively note public or online dissemination.
I didn't mean to suggest that the factor two was unique in that regard, but it is a frequent and recent example of something that comes up all the time.
Yes, Your Honor.
And so in a certain class of cases, I think we all understand that while we don't want to step into the shoes and conduct a de novo evaluation, attempting to emulate what the hearing examiner might have done, there are certain class of cases with a certain class of underlying information where we can do so with some fairly high level of confidence, high enough that we don't see a need for further procedural review.
The concern I have there, again, Your Honor, there's no doubt that those circumstances exist. The concern I see are the frequent decisions that say we may well have come to a different assessment of these facts.
But that is not this case. This case, you know, I mean, it involves some, shall we say, significantly aggravating circumstances.
The horrific expanded set of crimes or a single event, and there's no question there.
Right.
I would suggest that certainly as to the risk of reoffense, I think there's serious questions. To wit, there are 6 factors, risk factors, that the hearing examiner cites. There are 3 risk mitigating factors, and then there's these 2 weird mental health factors that are listed under the sort of risk assessment, but it's hard for me to gauge exactly what the hearing examiner was doing there. I mean, simple math is not inherently availing here, but the fact is that 18 and 19 are 1/3 of those factors, and 10, to whatever degree, is another. It's simply a significant portion of the risk of reoffense.
In some instances, the severity of the offense, the circumstances of the offense, suggest a disregard for ordinary boundaries that in and of themselves can give rise to a concern for reoffense. And I understand the distinction between dangerousness on the one hand and risk of reoffense on the other. In some circumstances, the complete wantonness, violence, disregard for norms of the act itself can display a level for concern of reoffense.
So I think my comment to that, Your Honor, is that as comparison, in thinking of this extra vulnerable factor, I feel extra vulnerable whenever anyone has an AK-47 near me. And that's fine, and that seems like a reasonable thing. That's just not what the factor asks.
She was also sleeping when the assault started.
Yeah, it's an interesting question about that, and in fact, I think in terms of the inquiry and the assessment, this is a 17-hour crime. The victim goes from being, I hate the sort of extra vulnerable, but the factor doesn't apply, and then does apply. Now, that may be totally reasonable, but there's no explanation for that, and I think there's some question. But once the AK-47 shows up, I fail to see how any other circumstances over the 17 hours are particularly going to change the vulnerability of the victim, and we don't have that analysis.
It's not the AK-47 in and of itself. The 17 hours, in fact, is a fairly troubling element of the scenario here.
There's no doubt that this is a horrific set of facts. There just isn't. The issue is that this is not a question of common sense, and it's not a question of how we feel about it. It's a question of whether or not there are scientific studies that validate the particular factors. And that's just it, right? I mean, so in terms of 18 and 19, we're bound by that. And it's a rules are rules situation that I'm sympathetic to that feeling, Your Honor, but I think the hearing examiner...
We've full circle in this conversation.
Well, except that the hearing examiner clearly established or found a number of factors that very strongly go to degree of danger. And it's very clear that this court and the SJC repeatedly say that there's these multiple elements, right? I mean, we can have all sorts of, we can have horrific incest crimes where online dissemination might not be appropriate, right? And I think it's that same question. I have 5 seconds left, but therefore I'll rest on Attorney Green's brief unless there are any additional questions.
Thank you.
Thank you so much, Your Honor.
Thank you again.
I'm happy.
Good morning.
Good morning.
Good morning. May it please the court, Jessica Blackman for the Sex Offender Registry Board. I'm not going to go over, sounds like everybody's aware of the facts and the violence that was committed in this situation with this offender. With regards to...
What if we think the hearing examiner got it wrong on factor 10? Is there still enough?
Yeah, absolutely. I think that with or without factor 10, I actually think that it's not an issue of whether he got it wrong. It's a matter of the argument here is that did he miss out on that factor when he didn't list the dispositions. So just because the hearing examiner in this case didn't list out the dispositions of each criminal
Right, but if
factor.
someone gets arrested 30 times, but they're only convicted twice, that has some meaning.
Under this factor, I would disagree. I think that when you read factor 10, it's contact with the criminal justice system. It's not limited to convictions only.
Do you have a case on that point?
I do. I don't have anything directly on point in that sense.
It does say dispositions in there.
It specifically lists out that the hearing examiner analysis under factor 10 is not limited only to convictions. Instead, it specifically requires consideration as to the number and types of charges, including their dispositions, the dates that the conduct occurred, the number of abuse and harassment prevention disorders, which the hearing examiner did here. He lists out the criminal activity that this offender has had contact with the criminal justice system, which included 11 criminal charges between Massachusetts and New York in a 2-year period. And the evidence that he considered with regards to that factor was the Board of Probation records, which in and of themselves lists out all of the contact, all of the offenses, and their dispositions. And in doing so, he considered all of that information. Because he didn't list out the dispositions of each one of those charges in his decision doesn't mean that he did not consider them. They're there.
Wouldn't it be better for the record to reflect that statement?
What was that? I'm sorry.
Wouldn't it be better for the record to reflect that explicit statement by the hearing examiner?
It may be better, yes. We probably wouldn't be having this argument at this point, but...
That goes into the better column as far as I'm concerned.
Yes,
As a
but...
matter of education for the hearing examiners, maybe it would be wise for the board to offer that encouragement.
Absolutely, I agree with you on that sense.
In your section of the brief on factor 10, you don't cite any cases.
Correct, so I'm not sure if there's anything directly on point. I know that they're not always listed out. I think the fact that he cites to
It'd be
the...
helpful to bring this conversation back to the board.
Absolutely. I agree with you on that. But I think...
We have these conversations, by the way, all the time.
Yes.
Okay, I agree with you.
Continuing legal education.
Exactly. I think the fact that he references the documents that he reviewed, meaning that was the Board of Probation record and the multi-state criminal record of this offender, you can infer from his review of those documents, which clearly outline the disposition of each case, that he did consider that information. But again, I think you have to go back to the fact that this factor does not limit review to and consideration of only convictions. It specifically lists all contact with the criminal justice system.
Let's move, if we could, to factor 18. What makes this victim extra vulnerable besides the fact that she was sleeping when the attack started?
That is what makes her extra vulnerable. In this case, under those facts, that rape which there were three, one of which was while she was sleeping, is what makes her extra vulnerable
Because she couldn't defend herself?
at that time. Yes, correct.
Cases that say that.
I do. So I can point to Doe 522366, which the court upheld the decision of the hearing examiner, which found the victim in that case to be extra vulnerable based on the fact that she was asleep at the time the assaults occurred, resulting in application of Factor 18 under those circumstances.
That's 52366?
522366.
Is that in your brief?
It is not. It's an unpublished decision.
Do you have any published decisions about Factor 18?
I do not before me. I can see if there are any. It submitted a 16L letter afterwards. But in that case, just as was the case here, that victim was asleep, and the court found that Factor 18 was properly applied in that case under the same or similar facts as here, where the victim was sleeping. Are there any other specific questions? I would just quickly address the denial of expert funds if there's nothing else on those two factors. I would just note that in this case, I think the evidence, I think the denial was proper on behalf of this examiner. In moving for expert funds, in this case, the plaintiff, Doe, failed to provide any records that would substantially or sufficiently address the nexus between this adjustment disorder that he was recently diagnosed with while incarcerated, and that the hearing examiner properly found that there was no evidence that connected the two. So that adjustment disorder or the mental illness he was suffering from at the time, there was no evidence provided by Doe at the hearing to sufficiently be able to draw any nexus between that disorder and his risk of reoffense or degree of dangerousness at that time. And as a result, that motion was properly denied. If there's nothing further, I would rest on my brief.
Seeing nothing, thank you.
Thank you.
Both. That brings us to the sixth and final case on our list for hearing this morning, case number 2022 P51, Jane Katie Kline versus Peter F. Kline. I'm advised that we have Attorney Silverman here. Attorney Kline, who is Attorney Clark, is not here, and Attorney Kline was also on this case as representing himself. We have not seen him. Is Attorney Clark here?
He's here, sir.
Ah. Well, that simplifies what I needed to do.
So is that the lawyer or is that the person?
You are?
Good morning. My name is Robert Clark. I represent the appellant, Peter Kline. I do apologize to the court. Well, having checked the list yesterday, I thought we were last and on for an 11:30 call. And again, my apologies.
We sometimes move through the list more quickly than on other occasions, and here we are.
I understand. I had to think that I was sitting upstairs in the library. If it please the court, this should be a straightforward case.
involving a couple who, after a very long-term marriage, divorced in 2012.
I might as well interrupt you right away. I don't think this is straightforward at all. I need your help.
Okay?
Can we consider the colloquy when the parties got divorced?
No.
Why?
It is excluded both by the terms of the agreement and also...
What do you mean it's excluded by the terms of the agreement?
The agreement itself provides that no extrinsic evidence or other conversations, or basically parole evidence, shall alter the construction of the agreement itself.
So if that's true, and the parties executed an agreement on December 13th of 2012, and the Alimony Reform Act had an effective date of March 1st, 2012, is it then fair to infer, that everyone was aware of the terms, including 49F?
Yes, both parties were represented by counsel.
So then why do I not next infer that they did not intend to have a termination date?
Well, that would be contrary to the statute, and I guess the question is whether the statute applies and controls the interpretation of this agreement.
If they were aware of the statute at the time that they signed their agreement and that the judge approved it, is it your view that in order to accomplish what Mrs. KLINE said they were trying to accomplish, they should have put into the separation agreement that the parties recognize that alimony is not going to terminate on his reaching Social Security retirement age?
Yes, that would be consistent with Section 49F. And also, I think, conversely, the construction that the parties would have had to have included express termination language within the agreement almost goes back to Judge Keeney's findings in Pierce, which was really the triggering event for the passage of the Alimony Reform Act in 2011.
So if I adopt your argument, what do I make of the evidence that he continued to pay for 5 years past his presumptive termination date?
That was by choice. And I guess I should, to digress, I have done Mr. KLINE's taxes with him every year since he filed his 2011 returns in early 2012.
None of this is in the record, though, counsel. My question is, what can we infer from your client's conduct in continuing to pay the full amount of alimony after his presumptive termination date pursuant to 49F?
That he chose to continue paying alimony.
And it has no bearing on the question of whether or not this was subject to modification or not?
I don't think it had, to rephrase your question, Judge, I would say that it doesn't have any bearing on the application of the statute.
But there's a substantial body of law that looks to the conduct of the parties acting pursuant to the agreement in construing their intent in forming the agreement.
Correct.
So I think that Judge Blake's question is the continued payment of alimony reflects an understanding of what the parties' agreement meant.
It may, but on its own, I can't say, well,
it's a fact.
It can't be said that would constitute a waiver of his rights under the statute.
That's not where I was going. I was going, we have, you're arguing the effect of the agreement and the words used in the contract read against the statute. And Judge Blake has offered a contrary alternative interpretation of those words. And in trying to look at how we interpret those words, the behavior of the parties acting pursuant to the agreement is a factor that we use in construing it. And that gets us back to her threshold question about the role of extrinsic evidence. The mere presence of a clause in a written contract that excludes consideration of extrinsic evidence, or an integration clause, commonly phrased, doesn't determine the question if there is ambiguity in the agreement that requires resort to extrinsic evidence to ascertain the party's intent.
I think that would be something of a reach,
in that there is no guarantee under these circumstances that that extrinsic evidence could still be accessed at the time of the complaint for contempt was filed. 7.5 years later, the probate court obviously is
That
under...
makes us no different from any other, not any other, but many, many other contract disputes where we have to engage in that inquiry. The fact that it's hard doesn't mean that we don't nonetheless have to try, or that we are precluded or barred from doing so.
Fair enough, but to take it a step further and to adopt the plaintiff's construction would require really a further step, that continued action, or actually the colloquy itself, which the existence of which, as evidence, is ambiguous at best, or Mr. Kline's actions in continuing to pay alimony somehow constituted a waiver. And really, I think going back to the, and if the court would indulge me, the one case that I did not cite, because I really wanted to focus on really the nuts and bolts of this matter was, of course, Pierce.
But Pierce is a pre-ARA case, right?
Absolutely.
Well, I want to ask you a different question then. Do contract principles even apply here as it relates to extrinsic evidence if the provisions relating to alimony merged and did not remain as an independent contract?
To an extent, if they merged.
Well, the alimony provision merged into the judgment, correct?
Correct.
And so that means it did not retain independent legal significance the way, for example, the asset division did.
Correct.
So should we even be looking at this through the lens of a contract if this is a merged agreement?
I think it's more of a hybrid. It is a contract that must be read in light of the controlling statute.
And what is the impact of the merger then on that contract?
The impact of
Right, your client couldn't sue independently on this. It has to be in an action in the probate and family court because it didn't retain independent legal significance.
Correct.
So I guess, how do we apply contract principles in that scenario?
Well, I don't think, in that scenario, I don't think it would really be necessary because in this case, the alimony recipient's right to seek a modification to extend the alimony obligation remains there. She has not exercised it to this point, but the standards are there, and obviously there are plenty of situations in which probate courts have extended obligations beyond retirement age, or at least beyond the presumptive.
But the need to seek a modification begs the question, doesn't it? It depends on you have to start with a threshold determination of the terms of the underlying decree in the first instance, setting aside any question of whether in construing the decree we engage in contract interpretation in its purest form.
Well, I can't say we need to engage in contract interpretation in its purest form because, as Judge Blake observed, this is a merging agreement, and it really remains under the jurisdiction of the probate court. However, we cannot. Well, the terms of the agreement cannot be separated from the controlling statute, and
that would be true even if a decree had entered in exactly the same form, imposed by the judge without participation by the parties in submitting an agreement, right?
That is correct. And in that case, the statute clearly would apply.
And were we to attempt to interpret the terms of the decree in light of the statute, we would need to engage in some form on the presence or absence of explicit language on the continuing obligation question, right?
In this case, there would need to be explicit language with respect to a continuing obligation. And I think that is that is where the statute and Section 49F in particular reversed the decision in Pierce. It created a statutory presumption, or created the statutory presumption, or created, I'm sorry, the presumption that Judge Pierce had requested, and really formalized it. Now, it obviously remains a rebuttable presumption, but until the presumption is rebutted, it needs to apply.
But if this had gone to judgment and the parties didn't settle it, and the amount was $649 a week, it would merge by operation of law. But wouldn't the judge, notwithstanding the statute, still have had to terminate it on death, or remarriage? And we don't have that language here. So presumably, if Mrs. Kline were remarried under the terms of their separation agreement, alimony would continue.
Well, under the statute, obviously the judge could not have imposed language requiring termination on death or remarriage. I mean, that was the issue in Clement. However, the judge could have made findings that it was in the interest of justice that, following the Section 53E factors, to extend beyond the presumptive termination date.
I think one of the things that's hard for me on this is that it came by way of a complaint for contempt, as opposed to some sort of a mod. So did you request any additional findings from the contempt judge?
We did not.
Did you submit proposed findings? I didn't see them in the record.
No, we did not.
And this was based on representation of counsel?
It was. This was July of 2020, and we were still handling everything by Zoom.
And your motion to dismiss was a 12B6 motion relying on the language of the statute?
That's correct.
There was a reference in the record to your client continuing to pay alimony while he was working, but that it was a period when he was unpaid for his work? Do you know what that period of time was?
He was paid through the end of 2019, and thereafter, he remained unpaid, and he stopped paying alimony in early 2020. No, I'm sorry. He was paid through 2020 and was no longer paid in...
Well, his birthday was January 2020, and that's when he turned 70 and stopped paying, right?
His birthday was in July of 20... he turned 70 July of 2019. And it was about
So when was he paid through?
Through 2020.
Do you think Chin versus Marriott and that trilogy of cases that came out of the SJC at that time has any impact on this case?
I do not, because in this case, we're not seeking retroactive application.
So there's no uncodified aspects of the statute that relate to this question?
Certainly none that I'm aware of.
And you don't disagree that a judge can order alimony beyond the durational limit if so-called justice requires, but you would say that, I think rightly so, that the burden would be on, in this case, the wife to come forward with that?
Yes, and further pursuant to Section 49F, those findings would need to be by clear and convincing evidence.
Is there anything in the record that addresses what the wife's disabilities were or are beyond what's in the colloquy from the time of the divorce hearing?
I am not certain. I know that, having been present, obviously, at the time of the divorce, I'm familiar with her condition. But by the same token, I'm also familiar with the asset division, and that the party should have been left with substantially similar assets.
And it's fair to say there's no case that we have published or the SJC has decided that stands for the proposition that you're arguing today. You say it's just a case of statutory interpretation.
It is a case of statutory interpretation, and I have been able to identify no case law contrary to it.
Sorry.
That's all right. Thank you.
Thank you very much.
For the wife?
Good morning, Your Honors. My name is Attorney J. Daniel Silverman. I represent the wife, Jane Kline. She is present here today.
Silverman, before you get started, and forgive me because I'm not as familiar with this area of law as my colleague to the left. Probably not as familiar as my colleague to the right. But when we find ourselves weighing a question of civil contempt, how much does it matter that we are, as Judge Blake just recognized, dealing here with a question of legal novelty?
Legal what?
Legal novelty.
Oh, okay.
I hesitate to use the term first impression, but if there are no settled appellate decisions concerning the question of statutory interpretation at issue here, how can we say that there was a clear and unequivocal disobedience of a clear and unambiguous command?
Well, I would suggest to the court, as Her Honor also suggested, that we look at the construction and the behavior of the particular client.
No, but even with that, I mean, and I know that that the contempt mechanism is often resorted to in probate and family law, particularly domestic relations, as a vehicle for enforcement. But a finding of contempt nonetheless requires a willful disobedience. And if someone has a good faith belief that what they are doing is dictated by statute based on an interpretation that has not been addressed by the courts, how can they be held in contempt with all that that entails?
Well, again, this was not a case where my client just rushed into court and did a contempt hearing. Actually, there was negotiations prior to for almost, I believe, 6 or 8 months.
I mean, wouldn't the more appropriate vehicle be a declaratory judgment? Or a complaint for a request for guidance from the court? I'm just a simple country lawyer trying to apply the principles that I've been brought up with in the context of civil contempt.
Well, one of the problems, Your Honors, is I didn't represent Ms. Klein down below.
Well, I'm not
Right,
challenging any, there's nothing immoral or fattening about any of this. I'm just trying to sort out the proper analytical construct. What we have at the center of this case, I understand, is a terribly important question of statutory interpretation that will apply to many, many other cases. But we have to decide this one.
Right.
And this one comes to us on a platform of civil contempt that I'm having trouble entering.
Well, again, under the separation agreement, it did call for payment of attorney's fees, and I believe the judge took that into consideration. I actually argued that part of the hearing. I wasn't on board for the first part of the hearing, meaning the July hearing. I came in December. But I think when she looked at the statutory interpretation of the separation agreement, it clearly called for attorney's fees. I will note that Burns and Levinson was asking about $36,000 in attorney's fees, and she cut it down to $22,000. And I believe her rationale was the fact that Mr. Klein just unilaterally decided not to pay any more alimony.
Well, but let's put the attorney's fees aside for a moment. I know you've asked for them on appeal as well, and the statute says what the statute says about contempts. But if we're going to talk about what the terms of this agreement said, as the chief pointed out, if this is such a legal novelty, it's hard to understand how this meets the Burchell threshold. But I want to put that aside for a second in the interest of time. We can consider parole evidence, right, if the separation agreement is ambiguous. And I'm going to guess that you're going to argue to me, well, of course it's ambiguous, that's why we're here, that's why we're having this discussion. The trouble, and I know I'm not meaning to shoot the messenger, I know you are not counsel for this piece, but at the contempt hearing, at transcript page 7, starting at line 8, it says, and this is Mrs. Klein's lawyer, The clear and unequivocal language of the separation agreement is that alimony is to continue indefinitely. If it's clear and unequivocal, the colloquy with Judge Monks is out. If the colloquy with Judge Monks is out, then it's a case of statutory interpretation, and the words in the statute say what they say. So tell me why we can consider what happened before Judge Monks at the colloquy at the divorce hearing.
Well, if you read the colloquy,
Oh, I've read it several times.
right,
Can I consider it? What's the law that allows me to consider it if her own lawyers acknowledge that the separation agreement was, quote, clear and unequivocal?
well, I think it, again, goes down to the construction of what Mr. Kline was doing. Certainly at the colloquy, there was no secret that she was disabled and that there was no termination language in there.
And that would be fantastic evidence on your side of the V.
Right.
But you have to get me through the door. How do I consider that, or how do we as a panel consider that, if she stipulated essentially that the agreement was clear and unequivocal, and therefore we don't take parole evidence?
Well, I would suggest that in this particular case, you have to take parole evidence, given the fact that the parties had an understanding.
But I'm asking you to help me.
I am, I'm trying.
How do I get there? Give me a case, give me a rule, give me a statute, something that says, even though she says the agreement is clear and unequivocal, we can still look at extrinsic evidence.
Well, I'm not aware of any case at this point. But that doesn't negate the fact that there was an intention to continue the alimony throughout the time that Mr. Kline voluntarily paid it.
Well, I guess that's my next question then. Let's assume that we don't consider what transpired at the colloquy. What do we do with the fact that he continued to pay for 5 additional years after he reached Social Security retirement age? How does that factor in?
Well, again, I think it factors in the fact that that was his understanding of the agreement, that he was going to continue to make payments. And it would have been a simple procedure had Mr. Kline's attorney just filed for a modification, and that probably would have helped, at least brought the court's attention as to what needed to be done. But he just unilaterally decided he wasn't going to pay it. And again, there were discussions prior to going into court about whether or not the statute applied or it didn't apply, and apparently my client chose to file a contempt. And again, everything that my brother cites seems to be for pre-reform.
I don't think Pierce carries the day here,
Yeah.
just so we're clear.
Yeah.
But I guess I'm struggling with, no one has said that there is a case. I have not found a case that stands for the proposition that if parties don't put any limiting language in their separation agreement, and someone continues to pay past Social Security retirement age, and then just stops, that constitutes a contempt, a civil contempt.
Well, there is 49C, which basically states that for marriages 20 years or above, alimony can be indefinite.
Right, and this doesn't fall within the durational limits for time, right? This is an open-ended alimony.
Right.
But it doesn't say it terminates on death, or remarriage.
Correct.
It says nothing other than he's going to pay.
Correct.
So if he's 89 and not working and has spent all of his assets, you say under the separation agreement, he still has to pay unless he comes in and gets a mod.
Right, but it's not like he's just out in the clouds, because he did eventually stop payment and then we had the litigation, and then he went to the court, and the judge herself asked Mr. Clark, I believe, did you file a modification? And he said no. Subsequently, and I know this is not part of the record, but Mr. Clark has now filed a modification.
Well, we can't consider
I
that.
understand that, but...
So the fact that this part of the agreement merged, does that impact the contract analysis relative to extrinsic evidence?
I don't think so, because in the separation agreement, it does specify that alimony still is open-ended.
But does the agreement also contain the typical, I'm going to call it boilerplate language, that the parties aren't relying on any other promises or agreements outside the terms set forth in the agreement?
Not that I remember, no.
Do you have any case law for us on this question? The question being, in other words, how we apply ordinary principles of contract interpretation to a separation agreement that's merged into a decree?
No, I mean, I researched this a long time, and I couldn't really find anything. And
Fascinating to me. I mean, this is not a novel posture, quite apart from the novelty of the particular question of statutory interplay on this question. The idea of a separation agreement that may carry some inherent ambiguity merged into a decree that's all the time, and yet we don't have any guidance on how to apply contract principles to interpretation of the resulting decree.
Well, sometimes that's why we come to you.
And you relied on George for the proposition about what interest of justice means, is that correct?
Well, I think that's the standard.
Well, it's the standard, I think, if he had filed a mod
Right.
instead of self-help.
Right.
On Record Appendix 15, at the end of the alimony section, it says, in the event of a change of law, interpretation, or ruling, which alters the tax consequences, then the alimony would be adjusted accordingly. There is no other limiting language if the law were to change, right?
Correct.
So do you think DeMarco applies in these circumstances?
It could, I mean...
Right, DeMarco was where the judge thought the law was a particular way under the Alimony Reform Act, and then it turned out that the SJC disagreed. So I'm trying to figure out if the parties misunderstood their obligations under the Act, whether or not your client is entitled to relief, and if so, is it relief through a contempt? I'm really struggling with the contempt piece.
Well, contempt may not have been the proper vehicle, but that's what happened.
Well, that's a problem, isn't it?
Excuse me?
I said that's a problem, isn't it?
Well, I guess it is, but, I mean, that was the mechanism that was chosen, because, well, I don't know. I mean, the lawyer down below...
This was on there was a motion to dismiss.
There was a motion to dismiss on 12b6.
Very thinly developed evidentiary record, to the extent that evidence, other than the four corners of the decree, even matters.
Correct.
Judge Blake? Judge Meade? Anything further?
No, thank you, though, for your time.
Thank you. This case is not all that straightforward, to me at least, and we will wrestle with it as best we can, but thank you for your presentations. They've been helpful. That concludes the argument in this case, and with it, the session. We are adjourned.
All rise, please.